The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Welcome to today's webinar on the SBA's proposed rules implementing the National Defense Authorization Acts of 2016 and 2017 provisions impacting small businesses. The slide for today's session can be found on the Handouts tab of your GoToWebinar dashboard or at www.PilieroMazza.com/presentations. We will also send everyone a copy of the slides and a link to the recorded session after today's webinar. Presenting for you today is yours truly, Tony Frankel, Senior Partner here at the PilieroMazza with the Government Contracting Group, and my colleague, Sam Finnerty. Sam Finnerty works in the Government Contracting Group as well as the Litigation and Small Business and Advisory Services Group, where he helps our clients with a wide variety of different issues that our clients confront and contact us to help them on. For those of you who have never been to one of our webinars, to quickly summarize, we're a firm here in DC with offices also in Boulder that have been representing contractors for over 25 years, and as a firm that has been particularly immersed in government contracting issues for so many years, particularly representing small businesses, but also mid-sized and large firms, we regularly are asked by our clients to advise them on corporate labor and employment issues. And so we have practice areas that not only cover government contracting, but also the small business programs and advisory services, labor and employment, business and corporate, litigation, intellectual property, and technology rights. We strive to make sure that our clients and the community in general understand what is happening that may impact their business, particularly with regard to small business issues. One of the reasons we immediately indicated to the community that we were giving this webinar is because whenever the SBA or the government, different government agencies issue regulations that could impact our client base or government contractors in general, and we believe these regulations are important and that companies need to submit comments, we want to immediately educate the community as to what the government is doing and what issues are critical that they comment on. And one of the more telling things about this proposed rule that the SBA issued is that actually the SBA throughout invites comments on different issues. So it's pretty clear that even though the SBA has issued what are proposed rules that oftentimes ultimately get issued in a final form, given our experience over the years submitting comments to the SBA and other agencies, they are taken into account. And we've actually seen situations where only one comment from a client has resulted in a regulation being changed. So we think that the community needs to be aware of the fact that the SBA wants to hear from you and that these are important issues that the SBA needs the small business community and the large business community's input in order to fine-tune the regulations for the reality of what you face in the government contracting small business world and in general. If you are not on our mailing list, by the way, you can sign up for our newsletters and events announcements on upcoming webinars at our website at www.PilieroMazza.com. And be mindful that we are regularly doing these kinds of presentations on different issues, and we will be submitting comments to the SBA on the regulations. And one of the reasons for this webinar is to see if you who are attending the webinar will, speaking through whoever you normally deal with to submit comments to the government, or through us, if you will share them, because we think it's important that the community speaks with one voice on some of these issues. There may be divergences of views on some of these things, but it is important that we understand the different angles that people have with regard to the way the SBA is thinking about fine-tuning some of these rules. And so please feel free to send us your comments on what you think the SBA should be doing here, because we will be submitting comments by the current due date, which is February 4th. Now, turning to the presentation, we will speak briefly about some important small business legislative developments that do not have to do with the proposed rules, but we think are critical for the community to be aware of. Then we'll move into the recent proposed rules by the SBA and the FAR Council. So we are going to touch upon one slide involving FAR Council proposed rules. And then at the very end, we're just going to be mentioning, the importance of submitting comments to the proposed rules. And if we have time, we will go ahead and take questions and provide answers from our audience. Whether we do it during the presentation or afterwards will depend on how we're moving along and the questions that we receive, as any questions we believe are particularly salient to the subject at hand, we may address it right there if there seems to be some confusion. Otherwise, if we can't go through all the questions, we do have a significant number of attendees. We will follow up after the webinar with you who do have questions that we can't answer today. Now, real quickly, just wanted to make sure that that our audience was aware of the Small Business Runway Extension Act of 2018, which was passed by Congress late last year. And then the president signed it on December 17, 2018, which changed the period of measurement for small businesses to determine whether they qualify as small. As you all probably know, the current rules require that a firm determine whether it's small by looking back at the last 3-year average of receipts. However, now with this new law, it's a 5-year look back. Interestingly, there's a number of companies out there who are very happy with this because it's going to allow them to remain small for a longer period of time. For some other companies, this has not been great news because if they go back 5 years, now they're going to be large for a longer period of time than they originally anticipated. The one issue here, though, that has caused some confusion is that even though this law was passed and technically is the law of the land now, the SBA's regulations do not provide for a 5 year. They right now have not been amended and it could take some time. And the SBA has taken a position through a policy directive that they're going to continue looking at the 3-year rule as being the one that's effective. The SAM, for those of you who know registered on SAM, has a 3-year look back period. So there are going to be a number of changes that are going to have to be made to the SBA regulations and the SAM infrastructure to capture this new 5-year look back. So what companies should be aware of is that as far as the SBA is concerned, you should continue submitting proposals and indicating that you're an eligible small business based upon the 3-year look back. We anticipate there may be litigation on this down the road because there may be companies who will be certifying to being small based upon a 5-year look back and will use law as the basis for feeling that that's something that can be done legally. And then it may be that the GAO and the Court of Claims has to determine the right way. The next important law that everyone should be aware of is the VA Small Business Act, which moves VA's verification of SDVOSB and VOSB status to the SBA. And this is going to require that service-disabled veteran-owned small businesses be certified government-wide. There will be no more self-certification, but the SBA does need to create now this certification process. Right now, the only process they have is for 8A, and it is a complex process and can take some time and has been constantly tweaked over the years. So the SBA does have experience creating these programs, but the SDVO program is different. So it remains to be seen when that will be stood up. And then lastly, just wanted to make sure that the audience was aware of the fact that some highlights from the 2018 National Defense Authorization Act. One of the most important ones for hub zone companies is that the SBA has basically frozen the hub zone maps until January 1st, 2020, which is good for those companies who were concerned about whether the area that they had their principal place of business didn't qualify as a hub zone. This law regarding changes and revisions to the hub zone program, most of the revisions on other substantive terms are not going to go into effect until 2020. But it's important, we believe, for companies that are out there that are 8A, SDVO, small business, et cetera, to be looking at whether they may qualify for the hub zone program, because Congress clearly wants to continue authorizing the program, is tweaking it to make it as business friendly as possible. And it is one of these programs that is immune from the kind of challenges that other programs have, such as the 8A program, et cetera, which are race-based, and there are folks out there who are targeting it because it's viewed as an affirmative action program. The Hub Zone program is looked at as a jobs program, and to the extent that these programs, you don't ever know how they may change and their viability, the Hub Zone program looks like Congress is committed to keeping it around. There's also revised DFAR statements for purposes of emphasizing quality, timeliness, and price reasonableness. That's important for those of you competing for contracts with the DoD. And then two other changes that were made was increasing the threshold for under the simplified acquisition, so for simplified acquisitions to $250,000, and the micro purchase threshold was increased to $10,000. So the SBA has, not the SBA, Congress has increased these numbers so as to give companies more opportunities to go after work at the lower dollar figures. Now, turning to the significant rule changes proposed by the SBA, which is, I know why you're all here, there were just a significant number of changes that were made by the SBA. And these changes were all mandated by Congress through two different laws that were passed in the last 2 years. The SBA has actually moved fairly quickly in implementation of these laws because we've seen other laws that were passed many years ago that has taken much longer for the SBA to implement. These proposed revisions involve subcontracting plan requirements, which are going to be mostly applicable to large businesses, but for companies that are small or small disadvantaged businesses, WOSBs, it's critical that you know the significance that is being given to these subcontracting plan requirements, because there are so many opportunities that are available to small businesses from large businesses that have to meet the subcontracting goals. The proposal also deals with the non-manufacturer rule and IT value-added resellers, which Sam will be talking about, also set-asides within set-asides, the recertification rules, and these other issues that are discussed in the slides, so I'm not going to repeat them since you can look at them yourself, and we'll just go right into the next slide, which is subcontracting plans.
Thanks, Tony. As Tony mentioned, this is going to be an area that's particularly relevant to some of our large business attendees today. The proposed rule makes a couple of changes with regard to the requirements for subcontracting plans. The first one that's noted here is that the rule specifically provides that companies that fail to comply in good faith with the periodic reporting requirements or their duty to participate in studies and surveys requested by the government used to determine compliance with these subcontracting plans will now be found to be in material breach of the contract. This is significant because it has not previously been provided for in the rules. The rules have always required that you provide these reports, but it did not indicate that failing to do so would be a material breach. This potentially could subject some small business concerns, business concerns that fail to comply with these requirements to liquidated damages. But it is important to note that SBA in the rulemaking has stated that it's not aware of any case where a firm has actually been subjected to those liquidated damages. The rule provides a couple of examples of when a prime contractor will be found to have not complied in good faith with these requirements that are spelled out. I'll just give you a couple of those. Would be failing to timely submit subcontracting reports, failing to pay small business subcontractors in accordance with the terms of their contract, or failing to conduct market research when you're identifying potential small business subcontractors. Another change that the rule implements with regard to subcontracting plans is that it indicates that for businesses with commercial subcontracting plans, they have to include indirect costs in those goals. This is sort of a de minimis effect because, according to SBA, most contractors have already been doing this, but there had been some inconsistencies because contractors with commercial subcontracting plans had been historically required to include indirect costs when reporting in their summary subcontracting reports, but the rules had not expressly required them to include indirect costs in their subcontracting plan goals. So there had been some inconsistencies that SBA noticed when comparing the summary subcontracting reports to the commercial subcontracting plans. This is also significant because it would increase the small business subcontracting goal, which would therefore increase the amount of funds the prime contractor would be subcontracting a small business concerns, which obviously creates additional advantages for small business concerns to become a part of these larger contracts. The final change with regard to subcontracting plans proposed by the rule is that just more of a conformity thing with regard to compliance reviews. They're now going to be using the terms that are currently used by the FAR when discussing evaluating compliance with subcontracting plans. The next issue that the proposed rule touches on is that it creates some additional opportunities for small businesses and really large businesses that would like to go after work that's being set aside for concerns that are located in disaster areas. There's always been local area set-asides for large and small businesses. It's not a new concept, but the proposed rule will now be giving agencies the opportunity to take double credit towards their small business goals when they're awarding these types of contracts to small businesses that are in designated disaster areas. These disaster areas can be found on FEMA. It's pretty accessible to figure out where those areas are. And the rule gives a definition of what a concern is that's located in a disaster area. A concern will generally be found to qualify if for the last 12 months it's had its main office in the area and it's generated at least half of its gross revenues and employed at least half of the permanent employees. It also provides a number of factors if you don't fit that express definition that SBA will also consider in making this type of determination. It's going to look at things such as the location of your office, your current state licenses, your record of past work in the disaster area, any contractual history that you have with subcontractors in the disaster area, your gross revenues attributable to work in the area, and the number of employees that you employ from that disaster area. This is a real advantage for small businesses. If you happen to find yourself impacted by a national emergency or disaster and you're trying to figure out how to get yourself back on your feet, get your company up and running again, it's important to be aware that these opportunities are out there and that agencies might be pursuing them more readily now, given that they're allowed to take double credit when awarding these types of set-asides. It's not exclusive to small businesses either. There, potentially could be opportunities here for joint venture or subcontracts for large businesses that want to be able to go after some of this work in tandem with a small business that's located in one of these areas. The rule also makes more of a clarification with regard to the size standard that's applicable for information technology value-added reseller procurements with respect to the non-manufacturer rule. The rule confirms essentially that the size standard for these types of procurements under footnote 18 to the applicable NAICS Code for ITVAR procurements is 150 employees and it's not 500 employees. This had been noted if you read through the text of that footnote in the size standard tables, but there has apparently been some confusion because the non-manufacturer rule, these procurements are subject to the non-manufacturer rule, but the non-manufacturer rule itself has a 500 employee size standard. So SBA is issuing this rule in response to this confusion. Particularly, there was a size appeal recently where a firm unsuccessfully argued that the size standard for IT procurements should be the 500 employee standard that's used under the non-manufacturer rule. So to clarify this, SBA is amending the text of the non-manufacturer rule itself to now expressly state that a firm may qualify as a small business concern to provide manufactured products or other supply items as a non-manufacturer if, among other things, it doesn't exceed 500 employees, and then they're adding in express language now to indicate that that is 150 employees if we're talking about an ITVAR procurement. But these procurements, like I mentioned earlier, are still subject to the non-manufacturer rule, which generally provides that firms have to be primarily engaged in the wholesale or retail trade of the product. They have to be a small business concern, be a regular dealer in the product, and are going to supply the product of a domestic small business manufacturer unless SBA has expressly granted them a waiver. The proposed rule also makes a significant change in that it is now going to be permitting set-asides within set-asides. This is a fairly significant change. It's about a 180 turn from current SBA policy. Essentially what the rule would allow is for task orders under IDIQ contracts, for example, SBA would be able to conduct a further set-aside where that IDIQ contract at the master contract level had been set aside just for small business. The rule would now allow contracting officers on the task order level to make further set-asides for SBA's different socioeconomic programs. So if an IDIQ was a small business set-aside, this rule would give contracting officers the authority to further set aside orders for SDVOSBs, WOSBs, hub zones, or 8A concerns. It's important to note that SBA has actually chosen in the past it's proposed before or thought about proposing such a rule, but it's expressly chosen not to do so in the past because one of the obvious concerns here is that if you permit the agency rather to make further set-asides at the task order level, you might be disadvantaging some of those small businesses that invested the time and money to go after a small business IDIQ and then find out that because they don't hold any of the other certifications for SDVOSB or whatever the further set-aside that's being made, they might not have the opportunity now to go after these orders, and it might diminish the value of the IDI contract that they've spent significant resources trying to procure. SBA apparently doesn't believe that that's as big of a concern anymore, but it is expressly requesting comments from the industry. So if this is a rule that might impact you, we would advise that you submit comments because they would specifically like to know from the industry whether this rule would actually impact small business concerns, competitive ability to go after orders. SBA has also noted that a couple of the ways that this rule would actually be implemented in effect are that they could establish set-asides for socioeconomic programs at the order solicitation level under multiple award set-aside contracts, which seems like the most natural way to do it. Or they could actually establish socioeconomic set-aside pools at the master contract level, which would then allow them to make further set-asides when choosing where to place orders down the road. Given that they are saying that that might be a way that would be permissible in the future if this rule is passed how it's been proposed, it does call into question the propriety of some certain existing IDIQ contracts out there that are already using these types of set-aside pools at the master contract level. Certain IDIQ contracts such as OASIS already do this, and given SBA's comments here, it suggests that some of those procurement vehicles may not be fully compliant with the regulations as they stand today.
The next rule change that the SBA has proposed is building on ones that they've been making over the years regarding size recertification. As many of you may be aware, the SBA is very concerned about making sure that the agencies are reporting the proper data on contracts being performed by small businesses. And the SBA rules require recertification of size and status for all long-term contracts. Those are for over 5 years. And this includes IDIQ contracts under which orders will be placed at a future date, and contracts that have not been set aside for small businesses but were awarded to small businesses. And so one of the things the SBA is doing here with this regulation is they've indicated that they also want small businesses to recertify if there's a change in their status on a contract that was awarded to them on a full and open basis. And that is a change because the contract was not competed based upon the company's size, although we know that agencies do take credit when they award a contract on a full and open basis to a small business because they want to make sure that the databases show that they are actually awarding contracts to small businesses. What the SBA is doing here, though, is basically letting small businesses know that if they change their status while performing a contract that they competed on with other large businesses and they won, and because they perhaps won a very big contract and now large, these agencies can no longer take small business credit for the work being done by that company. The SBA is also adding what are called recertification requirements for 8A participants and SDB concerns which are already present in the regulations for SDVOSB, hub zone, and WSB regulations. And what we're talking about here is status recertification requirements, not size recertification requirements. The SBA for years has had these regulations that they've continued tweaking and concerning when a company grows and what they need to do if it's a growth that impacts them on a long-term contract, or if it's because of an acquisition or a merger or an ovation. But those are all size-related type recertifications. One of the things the SBA wanted to make sure is that these agencies were not continuing to take credit for work that was being done now by a firm that is no longer 8A. And so they've made sure that the 8A regulations now have a provision for size recertification, for status recertification for firms when they novate an 8A contract, and or if they are the subject, if they're an 8A firm that is acquired or acquires another firm. Now, you should know that currently under the SBA's size regulations, if you are a small business that's acquired another company, you need to recertify size. What the SBA, though, has indicated here, which is interesting, is that they believe that an 8A company that may continue to be 8A, but just has acquired another company, and continues to be small, and 8A still needs to go through this recertification process. Interestingly, too, the SBA's regulations make a reference to a provision regarding the fact that if you are an 8A company and you novate a contract that was awarded to you that was not an 8A contract, in those situations, they also want the company that acquired the contract that was a non-8A contract to certify as to whether they are an 8A or not 8A. And at first, when you look at it, initial reaction is this must be a typo. Why does the SBA cares about what an 8A company is doing with its non-8A contracts? But it looks like what the SBA is trying to get at is situations where a non-8A contract is transferred over to a company that is not 8A, but because the contract was originally awarded on to an 8A firm, the procuring agency is taking an 8A credit, even though it was not an 8A contract, but it was being performed by an 8A firm. So again, it looks like the SBA is trying to really drill down to how it is that these firms are performing the work and engaging in business practices that they believe may impact whether these companies qualify as large or small, or as 8A, or for purposes of the SDVO and WSBs, where there are already regulations in place. You have a situation where under those programs, these companies need to also be providing recertification. So, in a nutshell, just 8A companies that are going to be impacted by this rule should realize that there's another element of recertification they need to be aware of, not only when they're dealing with 8A contracts, but also with non-8A contracts. And one of the things that we think comments should be submitted on is the fact that the SBA actually indicates that if an 8A firm acquires another company, they need to then invoke a process for approval for a change of ownership and or a waiver of the requirement for termination of 8A contracts when you've sold them to a you've transferred them to a non-8A company or there's been a change of ownership, which doesn't happen every time an 8A company acquires an 8A company. So it seems that there needs to be some changes here because it's going to create, we believe, significantly additional regulatory burdens to 8A companies. And also, interestingly, the SBA's regulations discuss changes to the SDB certification rules. And as many of you know, there are really no SDB set-asides. Now, 8A firms are automatically SDBs, but the set-asides that are done for those firms are 8A set-asides. There's a number of regulations that the SBA has proposed that indicate that SDBs need to recertify as well when there's been a change in their status. And since there's no real contract awards directly to SDBs by the government, those are awards normally made by the primes. It's unclear what the SBA is getting at, because currently subcontractors do not have to recertify size to the government. They can recertify size to their prime if there's something in the prime contract that requires recertification, but there is no such recertification requirement imposed on subcontractors. And the language in the regulation that discusses size recertifications or status recertifications by SDBs doesn't really seem to make sense given the current programs and the fact that there are no set-asides for SDBs. But there are, of course, for 8As, and the 8A regulations deal with that.
Tony, while we're addressing this right now, I did see one comment from one of our listeners here, a question that was submitted that we can go ahead and try and answer right now, just as it popped on the screen here. One of our listeners asked whether we're saying if after 5 years a firm's no longer an 8A, it would lose a contract because it could no longer recertify as an 8A. And I think it's important to note, I think the question is not that they would lose the contract. They would still be able to hold the contract. The agency would just not be able to take credit for that contract going forward. And I'm not sure what type of contract the listener is referring to here, but if it were, for example, an IDIQ contract and there were awards that were still being placed under that contract, once the firm recertified that it was no longer an 8A, not only would the agency not be able to take credit, 8A credit for that contract going forward, but it also wouldn't be able to award any future orders under that contract that were 8A orders.
Exactly, and that's a good point because the SBA actually tweaked the recertification regulations last year in order to make clear that some misunderstandings regarding the status of a contract that is normally awarded, where it's understood that the status remains with the company for the life of the contract. But the SBA realized that felt that was being misconstrued given a case that had determined on an SDVO set aside that a service disabled veteran owned small business that had been acquired could still continue competing for work as an SDVOSB because they technically qualified as an SDVO for the life of the contract, given the regulations that existed back then. And I know that Sam worked closely on that issue earlier in the year, and when the SBA changed the regulations, they actually did it as part of a technical amendment without asking for comments from the public. But that is sort of consistent with what we're seeing the SBA is doing, which is they want to make sure that they're capturing as accurate data as possible regarding what companies are doing, what's the size and status of the companies doing the work, but that's also then flowing over and impacting these companies' ability to continue succeeding, which we believe is problematic because many of them work very hard to get these contracts. And just when they're getting the fruits of these contracts and engaging in, the practices that now that they should be able to engage in as larger businesses through novations, acquisitions, et cetera, risk losing those contracts or not being able to benefit because of the change in status.
We have a lot of experience counseling different companies on not only when recertification is required, but also the impact of recertification. So for anybody out there that's thinks they might have to recertify in the near future and they want to fully walk through the different implications that might have on their business and different opportunities that might be available to them, we'd be happy to help you out with that as well.
Now, the next slide here is and this is an important one for, I'm sure, for all our attendees, is the limitation on subcontracting regulations that the SBA is proposing. And this really goes to enforcement because the SBA does not think that this is being enforced enough. And what it's doing it's proposing to require contractors to submit information to aid contracting officers in monitoring compliance. And in issuing, this proposed rule, the SBA, in the comments explaining why they were doing this, they discussed the fact that there are a number of GAO reports that they believe highlight the fact that no one's really monitoring whether companies are meeting their performance of work requirements, or what's called the subcontract limitation rules. And, the SBA specifically asked for comments on whether all small primes performing set-asides or sole source contracts should be required to demonstrate compliance with the limitation of subcontracting clause, and if so, how? It's an interesting question. The SBA was asking for comments for that because as a precaution to any company that we would be working with or representing that is performing these contracts, they could be audited at any time. And because they could be audited or an investigation could all of a sudden arise, or some whistleblower could come along and claim that the company is not meeting the performance of work requirements, you need to have the data available. And so clearly, we can't see the community saying no, that there should be no obligation for small businesses to keep this kind of data available if the rules require that you comply with them. That said, you should note that one of the things the SBA wants contracting officers to know is that they have the discretion to monitor compliance. Because one of the things that we've seen in looking at these GAO reports is, the contracting officers believe that's SBA's problem, that the SBA should be enforcing it because it's an SBA regulation. The SBA believes that these were contracts awarded by the agencies, that there are FAR clauses regarding implementation of the subcontract limitation rule, and so the COs should be monitoring it. And the SBA really can't tell these procuring agencies what to do, but they're making pretty clear that the COs have the discretion to monitor. And there are three types of information that the SBA believes prime contractors and slash small businesses may be required to deliver here if they all of a sudden are audited, or a contracting officer wants to know how are you going to comply. Which, by the way, just this morning I received an email from a client who was bidding on a contract, and the contracting officer asked, how are you going to meet the performance of work rule? So these are things that companies should be prepared to explain. But if you've been awarded a contract, the SBA believes that a contracting officer may request a copy of the subcontract. They may ask for an email from the contractor listing the amounts paid to the subcontractors, and information as to whether the subcontractors are similarly situated, which, as many of you know, if you're subcontracting to a similarly situated entity, whatever work they're doing counts towards your performance of work requirements. In the regulations, the SBA specifically asks some questions that they want the community to answer on what information can be efficiently requested and provided. And I'm going to go through those here real quickly so that you'll see what kind of information the SBA wants. They're asking here, what salient data would best provide assurances of compliance? That's question number one. The question number two is, should demonstrating compliance depend on the length of the contract or the type of the contract? Should compliance depend on whether it's a commercial product and services? Also, SBA wants to know whether it matters if the contract is fixed price. Also, whether the contract is above the Simplified Acquisition threshold or the Truth in Negotiation Act thresholds. SBA also asked, what other considerations should there be when applying the requirements for a contractor to document the LOA's compliance? The fact that the SBA is asking these very specific questions shows that the SBA wants input from the community. They're not going to just impose this on you unless they really don't get comments from the community. It doesn't mean that we may still not get some requirements that we don't like or may be too onerous, but it's important for you to think about how your business operates and what kind of information it can make readily available to a contracting officer who asks for this information. Again, we're prepared to help you with answering these questions if you need help or if you have someone else within your organization, but it is important the SBA get responses to this. One of the other areas that we think is important regarding the limitation on subcontracting is that SBA has clarified when an independent contractor can be counted as an employee for size and limitation for subcontracting purposes. And you should know that this is really going to be more relevant to companies that are pursuing work that is assigned NAICS codes that are employee-based, under the employee-based size standards. Because the SBA has made clear that an independent contractor may be deemed an employee under the terms of an SBA policy statement that goes back many years, where the SBA laid out all the factors that may be considered in determining whether a company is employing someone or is really treating them like an independent contractor. And those are factors that actually are very similar to those the IRS uses in determining whether someone's an independent contractor or not. We normally have used those in general in determining whether someone's an independent contractor or employee, regardless of whether the work was being done by under a NAICS code that was employee-based or service-based, because the rules are what they are, and the SBA's regulations of what an employee is very clearly follows a test of what the IRS has always looked at. However, the SBA has, with the similarly situated rule that has gone into effect that allows companies to meet the limitation of subcontracting requirements through similarly situated entities, the SBA realizes that there's a potential there for abuse. So, when a contract is assigned a receipt-based size standard, an independent contractor cannot be considered an employee and will always be deemed a subcontractor. This probably is not going to be a big issue if you are working with companies that are owned by individuals and really they're solo practitioners and they qualify as small. But in those situations, they could be considered, similarly situated. But it will be a problem in other situations where you have larger small businesses that are not it's not just one individual and that may be large, and the fact that they have these employees that they're operating, if they're operating through employees, it's not gonna fly. So just be mindful of the fact that for purposes of the employee-based size standards, the individuals you bring in as independent contractors can count for both size purposes and limitation of subcontracting purposes. Now, one of the things that we also thought was important for our audience to understand is that the SBA is asking also for comments with regard to proposed exclusions for, under the limitation of subcontracting rule. With regard to cloud computing, the SBA has actually requested comments on how to define cloud computing because the SBA has realized that there are a number of costs that would be excluded from the limitation on subcontracting requirements when the small business is providing services that are not the primary requirements of the contract. And the SBA is looking to see comments for alternatives that would treat, for example, cloud computing as a supply, which would then subject it to the non-manufacturing rule. In the proposed rule, the SBA indicates, too, that they recognize that there are certain contracts where companies need to engage in what are media buys, and these can be very costly, and these are revenues that are flowing directly through the company to subcontractors. And as a result, with regard to media buys, they are looking to see whether they should be excluded in the determination. Similarly, with regard to transportation or disposal of hazardous materials. In the environmental remediation field, we know many companies that have indicated that when they receive a contract for environmental remediation, they have to spend a fortune on the transportation of hazardous materials. And those are really just pass-throughs that make them look large, and they have no choice but to go to large businesses to transport these kinds of materials because there aren't too many small businesses that do the work. And also with regard to travel, to the extent that a contract is awarded to a company that requires significant travel, those travel costs, normally when the government pays you for it, that hits your bottom line and it's counted against you. And so therefore, that's one of the things that the SBA is also looking at, whether the use of travel services by other companies that help you meet those needs of the government should be excluded. The SBA wants to know also what other cost should be excluded from the calculation. And this is really a great opportunity to explain to the SBA unique situations that each of you face in your industries that they may not know about. And they are receptive to making these changes because we know that for years many environmental remediation firms have talked to us about the transportation costs they have. And here it is finally in 2018 that the proposed rules have been issued. So we think this is important for you to think about, how you may want to carve out certain exceptions that will help your company. Now, lastly, this is slide deals with another proposed rule impacting the limitation on subcontracting. This was not issued by the SBA, but it was issued by the FAR Council, and this has been a long-awaited rule. Because the SBA, as many of you know, issued the new subcontract limitation rules based on receipts as opposed to your personnel cost 2 years ago. But because the FAR Council had not changed the regulations, many agencies continued following the FAR clauses that were incorporated into the contracts. So you have the SBA indicating you need to look at similar situated entities for SBA purposes, and also how much money are you really actually spending on subcontractors as opposed to you keeping for yourself and determining compliance. And yet you had the FAR Council rule that would continue doing it based upon your labor cost. And finally, the FAR Council has issued a proposed rule that will implement the SBA's rule so that they mirror image each other. And we found particularly interesting that in December, around the same time this rule was issued, the DOD issued a class deviation that was effective immediately, which implements the SBA's formulation of the limitation of subcontracting clause. And we think that's critical because, as you know, there's so much money that flows through the procurement system from the DOD, and the DOD had been pretty adamant that they were not going to follow the SBA's rule until the FAR was changed. We think that because the FAR Council has moved forward with this proposed rule, the DOD felt comfortable that they could start adopting the SBA standard, even though it's not in a final rule, but it's through a policy directive allowing contracting officers to make these changes.
The proposed rule also, importantly, it creates a new protest ground for potential unsuccessful offerors out there that is going to allow protests of a prime contractor that's unduly reliant on a small but not necessarily similarly situated subcontractor under what's known as the Ostensible Subcontractor rule. Under that rule, traditionally, affiliation is found when a small business is unduly reliant on an other than small subcontractor, or when the other than small subcontractor is going to perform the primary and vital requirements of the contract. This is one of the most common size protest grounds that's alleged in a size protest. A lot of times you don't have a ton of information on the awardee when you're filing a size protest, and based on information that you can drum up online, information you know about the award, you might have reason to believe that the prime contract awardee is not actually going to be performing the primary and vital requirements as they're required. And so there are allegations that are often raised that they're presumably unduly reliant on what's known as an ostensible subcontractor. The rule that's being proposed now is that SBA is going to make an offeror ineligible for a set-aside if the prime contractor has a small business ostensible subcontractor that does not qualify for the required socioeconomic status. So, for example, if the prime contract is set aside for SDVOSBs and an SDVOSB prime is found to have an ostensible subcontractor that is a small business, but, for example, not an SDVOSB, it might be a woman-owned small business, and that woman-owned small business subcontractor is going to be performing the primary and vital requirements, or the prime is going to be unduly reliant on that woman-owned small business, they would be found to be an ostensible subcontractor, and the two firms would be deemed affiliated, and their receipts or employees aggregated for determining size. This is important because it has a particular impact on joint ventures that are created under SBA's recent joint venture regulations that were enacted a couple of years ago. Because under those regulations, a joint venture receives an exception from affiliation if both the joint venturers are small under the applicable NAICS codes. So if an 8A contract, for example, is awarded to a joint venture between an 8A concern and a small business, even if there is a concern that the contract would be primarily performed by the small business joint venture partner that is not the 8A partner upon which eligibility for that contract's based. As it stands right now, there's currently no way to protest the awardee on the basis that the 8A prime is unduly reliant on its ostensible subcontractor, the small business joint venture partner that's going to be performing the primary and vital requirements of the contract, because the SBA's new joint venture regulations expressly exempt small business joint venture partners from a finding of affiliation. So this will now bring the rule more in conformity with the general notion that a prime contractor awardee and its ostensible subcontractor are deemed affiliates, and that their sizes, their employees, or their receipts will be aggregated for size determination purposes. It's also important to note now that SBA indicated that if it does find ostensible subcontractor affiliation in these circumstances where you've got a joint venture, it's going to analyze whether that concern that's a joint venture between two small business concerns meets the strict requirements that are imposed by SBA's new joint venture regulations, which have pretty exacting requirements when it comes to the content of the joint venture agreement that those two concerns have to have in place. So it's something to consider if you're forming a joint venture. The rule also has an impact on kit assemblers. The SBA is proposing to remove kit assemblers, the kit assembler exception from the kit assembler exception to the NMR, and instead SBA is going to apply the multiple item rule to kit assembler acquisitions. This means that if the majority of the items in the kit are made by a small business, the awardee will no longer have to request a waiver of the NMR. But if the majority of the items are not made by a small business, a waiver of the NMR will still be obtained. Currently the existing kit assembler rule requires that 50% of the total value of the items in the kit have to be manufactured by small business concerns, but excludes items manufactured by other than small business concerns if the contracting officer specifies the item for the kit. This rule had led to some confusion concerning how to calculate total value and whether a waiver of the non-manufacturer rule had to be requested in order to supply items manufactured by other than small business concerns. So this should hopefully simplify things by making it more clear when a waiver of the NMR is required and when a waiver is not required. The proposed rule is also revising the regulations slightly to clarify when size is determined. As the rule currently provides, this is 121.404A, provides that SBA determines the size status of a concern, including its affiliates, as of the date the concern submits a written self-certification as part of its initial offer, or other formal response to a solicitation, which includes price. According to SBA, some parties have misread the phrase there, or other formal response to solicitation, to mean that formal responses that are after the initial offer, such as final proposal revisions, would control for purposes of determining size. That is not the case. Size is not determined when other formal responses are received after the initial offer. So it's clarifying it by removing that parenthetical language indicating other formal responses to a solicitation. SBA is also proposing an exception to this rule, which would allow for size to be determined on the date of initial offer for the contract, which may not include price when an agency awards a multiple award contract that does not require offers for the contract to include price at that time. SBA is also proposing to clarify in the rule where one acceptable offer is received on a set-aside. It's going to confirm that if a CO receives only one acceptable offer from a small business concern in response to a set-aside solicitation, the CO should make an award to that firm. The FAR currently provides this rule, but it only requires the CO to make such an award where the set-aside is below $150,000. According to SBA, this policy should be extended to all set-aside contracts. They believe that it'd be inefficient and detrimental to the government and to offerors to arbitrarily prevent an award where there was a competition that was conducted, but there was only one offer that was received. It's important to note that the decision to set aside is supposed to be based on a contracting officer's expectation from market research that it's going to receive 2 or more fair market offers from capable small business contracting, from small business concerns. It doesn't matter whether it actually does, as long as the market research leads a CO to this conclusion, they've satisfied the rule of 2, no matter how many offers are actually received, and SBA believes that in those circumstances where there's only one offer, COs should be required to make an award to that firm that's a responsible offeror. As we mentioned at the outset of this, the comments for this proposed rule that touches on a lot of different small business contracting issues, many of which we just went over. There's a couple of other minor changes that we didn't have time to touch on, but the comments for this are going to be due on February 4th, which is right around the corner. So given the number of issues this touches on, the intricacies and nuances of the rulemaking, and the language provided by SBA to support the actual regulations that would be adopted, companies that want to submit comments, we would urge you to start undertaking that process. We would be more than happy to help you do that. This is a proposed rule that has a lot of effect on small business contracting, and there's many issues that may impact a lot of our small business and large business listeners today that are in the audience. So if you have any desire to submit comments, or you want to know what sections of the proposed rule might impact your business specifically, we'd be more than happy to walk that through with you, and also, work with you on drafting comments to SBA to submit by the February 4th deadline.
And I'd like to really briefly summarize for our audience the questions that the SBA specifically has asked comments on. The first question the SBA had is they're requesting comments on whether the SBA should allow agencies to set aside orders for socioeconomic small business programs, NDAA, HubZone, SDVO, and WSBs under a multiple award contract that was originally conducted as a total small business set-aside. The SBA is also requesting comments on any burdens or adverse impacts associated with each of these, with this approach of allowing these set-asides. The SBA is also requesting comments on whether all small business prime contractors performing set-aside or sole source contracts should be required to demonstrate compliance with the limitation on subcontracting to the contracting officer, and if so, how often should that be required, such as annually or quarterly. The SBA then asks a number of questions regarding the kind of data, but at the end of the list of questions that I identified earlier, the SBA summarized by saying we are requesting that industry provide comments on what information can be efficiently requested and provided. The SBA is also requesting comments on whether it should treat cloud computing as a supply, and therefore should the non-manufacturer rule should apply. SBA is also requesting comments on the definition of cloud computing, such as a definition in the National Institute of Standards and Technology, so they can ensure that definition is not used to allow other than small businesses to provide an excessive portion of services on small business set-asides. The SBA is also requesting comments on whether these types of costs should be excluded from the calculation of purposes of compliance with the LOS. And they give a number of examples. And the SBA again reiterates they would like to have comments on what should be some of the exclusions to the limitation on subcontracting clause. And then lastly, I know that one of the questions that came in during this presentation was the question regarding where do we submit comments. Like I said, we'd be more than happy to help you in the submission of comments, but to the extent some of you are thinking about doing this on your own, the SBA's proposed rule indicates that this can be done through the federal e-rulemaking portal at http://www.regulations.gov. And then you need to follow certain instructions here for the submitting of comments. You can also submit by paper, disc, or CD-ROM to the attention of Brenda Fernandez at the SBA. She is with the Office of Policy, Planning, and Liaisons at 409 3rd Street Southwest, 8th floor, Washington, D.C. Also, keep in mind that if you decide to do these on your own, and you're submitting comments that discuss information that's proprietary and confidential to your company, you need to let the SBA know that you want that information to be treated as such. Whenever comments are submitted to the SBA, they are normally open to the public. And the public can go in there and read all these comments that all these companies are submitting. So your competitors may get information that you do not want out there. The SBA does reserve the right to release information that they believe should be available to the public. So just keep that in mind if you're going to do this on your own. Normally when we're submitting comments, we are assuming they're going to be distributed to the public. But if you want something particularly customized to your situation, we can definitely help you do that and try to make the best case possible as to why the information should be protected. We know, one of the questions we just received is, since the SBA is not open, does that change the comment period? Right now, until they've formally changed the comment period, you should consider this to be the date that you have to submit the comments. Interestingly, there were some other comments that the SBA was looking to receive on the HubZone rules. We submitted comments on the HubZone rule about 10 days ago. I think it was the deadline. One of my other colleagues worked on those comments. But it was interesting because after we submitted comments, the SBA actually issued in the Federal Register notice extending the due date for comments on the HubZone regulations. So clearly there are some people within the agency who are following this. And so it may be that this comment period is extended. But we're not sure, and we need to operate based upon the current deadline. And keep in mind that the HubZone one, I don't think was changed until the day that they were actually due. And I think we submitted them a day or two early. But we need to be thinking, all of you need to be thinking about trying to meet that deadline. And hopefully it does get extended because of the situation with the government closing. We have had a significant number of attendees at today's presentation and a number of questions. Unfortunately, we really can't go through all of them, but we do value your participation and input, and your questions actually are a great way for us to communicate with you and give you insight on some of the information we have here. Also, it obviously helps us sometimes when you ask questions that we can't, ask off the top of our head, to become further entrenched in the regulations and further our expertise because of all the different nuances we receive from our audience. So we will get back to those of you who've asked so many great questions that we will have to answer right now, but we're hitting 3 o'clock and we thought it was more important to just go through these comments. And if there's anything that was unclear, our apologies, and we're here to try to clarify anything because this was a lot of material to try to cover in 1 hour. Thank you very much and have a nice day.